Hi, good morning, everybody. Welcome. My name is Tiva Suleiman. I am a director here at Cliffe Dekker Hofmeyr, and I head up a sector for technology and communications. So to start off, I'm always wary about the fact that there are a few participants that are still joining. So perhaps we could just give people a minute or two. But while we get ready to get going, perhaps just to let all of the participants who have joined know that the format of today's webinar is going to be the panel sort of having a discussion in terms of the legal and ethical considerations on AI. And you are welcome to post any questions that come to mind in the course of the presentation or in terms of the panel discussion into the chat box. And at the end, hopefully somebody will be able to answer the questions. If none of us can answer it, I'm quite certain that maybe we can refer some of the questions to AI. I see that we've still got a couple of people joining. I might give people a minute or two. For all the Cape Townians, I hope you're snug and warm. But I'm very pleased to say that spring has arrived in Gauteng. I thought we'd get to the good old round number of 60, and it seems like we got there. So perhaps better to get going. So we have from a Cliffe Dekker Hofmeyr perspective, we have a very warm and collaborative working relationship with our colleagues at Spoor Fisher. And we're very fortunate to have a few of the members of Spoor Fisher on the panel today. We have recently all collaborated on submissions to Chambers International for the AI Law and Practice Guide. So it's certainly at the forefront of all of our minds personally and in our practices. I'm just going to do a little bit of a brief introduction in terms of my colleagues from Spoor Fisher joining me on the panel this morning. I was just about to say this afternoon. Who knows where the day is going? The first person that I'm going to be introducing is Dina Biagio. She's a partner at Spoor Fisher. She has an extraordinary career in terms of having qualified in physics, electrical engineering, and law. And her focal point is in terms of IP development, the licensing, freedom to operate, analysis, and IP valuation. So welcome and thank you very much, Dina Biagio, for joining us on the panel this morning. Our next partner from Spoor Fisher is Herman van Schalkwyk. He is today the rose amongst thorns. Also partner at Spoor Fisher, he leads the firm's digital and transformation efforts. And he has conveyed to me that he has a particular interest in AI with a deep understanding of the practical and ethical aspects and implementation for businesses. Our last panel member that I'm going to be introducing this morning is Vanessa van Copenhagen, who very sort of corrected me, not Copenhagen, like Denmark this morning. And Vanessa is a consultant attorney at Spoor Fisher with an extensive career in corporate transactional law and commercial IP law. She's also handled a number of IP and corporate acquisitions, disposals across the private and public and private sector and for nonprofits forward. So that's Vanessa, who's also joining us this morning on the panel. So let's perhaps get into it, because AI is obviously very topical. When we ask our clients, what should we be addressing in terms of training? What should we be addressing in terms of webinars? We almost on a 99% basis get requests for training and for webinars to be presented on AI. And it is an extensive topic. When we were preparing for this, we thought we could probably put together a series of 10 webinars in terms of the content. So we're certainly not going to be well placed to get to everything today. But when when you start to consider the construct of AI, people often think, it's something that's come to ubiquitous use perhaps in the last couple of years, but its origins go way back, probably into the 50s, where it became a, more defined discipline of the sciences. And there's been a steady sort of interest in terms of AI and the implications for AI, but perhaps in the last 10 odd years, the construct of deep learning has influenced the way that technology has developed. The capacity in terms of computing has sort of changed the framework and almost introduced it into mainstream usage. And on that sort of theme, perhaps it's a good place to start with, what AI is in terms of those AI innovations that are shaping the way that we live, that are shaping the world in which we live in, and that are shaping, the way that we are going to continue to do business in the future. And perhaps I can turn to you, Herman, to start with. What are we looking at for the future?
Thank you, Eva. Yeah, that's certainly interesting. I mean, like you say, it's not a new field. I think it's old. The underlying models are old, but ever since the release of ChatGPT and generative AI, it is all of a sudden mainstream hype. But those underlying technologies are really changing all sectors. I mean, essentially, these processes allow for more efficient and adaptive processes than ever before. And it's cutting across all industries, whether it's legal, professional services, financial services, healthcare, agriculture, manufacturing. We're all getting affected. And those industries that produce digital products with knowledge work getting produced with a fairly high repetitive nature, I mean, those industries will find severe disruption. And the legal industry is probably a good example of such an industry where we can expect disruption. But essentially, these AI technologies, they're aimed at, they allow quicker and more informed decision making. They allow for the processing of vast amounts of data, for the analysis of that data. They allow for superior human machine collaboration that allow for innovative processes that drive greater profit margins. But essentially, if you look at a user perspective, these AI technologies aim at improving the overall experience, whether that's from the customer's perspective or whether from the service provider's perspective and the employee's perspective. It's aimed at improving that experience. But there is also a warning for the future, and that we should look at AI to improve the overall experience and not detract from it. And by that I mean, AI shouldn't replace those parts of a person's daily activities, whether it be work or whatever they enjoy, where they find joy and fulfillment. It should, we shouldn't outsource that to AI, and then we're stuck with the administrative task of managing the AI. So I think looking to the future, that I think is we need to be responsible in the way we use AI so that it kind of enhances the experience and not detract from it.
Yeah, thanks for that, Herman. The part I really liked is when you said don't outsource your life to the AI, because I think that there's a risk. Somebody was mentioned yesterday that on her way to work, she's got an app that basically pops up and says, "Hey, you the closest Tasha's is 10 minutes away," because it's basically figured out that she likes coffee from Tasha's. And so yeah, it's whether we're going to be outsourcing our lives to AI is an interesting thing. And there's so many functions and innovations that are sort of being constantly developed, certainly within the legal industry, within other industries, and it's absolutely changing the format of how we contemplate the application of the law. And I was at the parliamentary hearings for the Department of Communications and Digital Technologies last week for their portfolio committee hearings, and they talked a lot about what's on the horizon, and Meta and Google were presenting at these hearings, and they were talking to Llama and Gemini, and you know, the various state agencies are contemplating that AI is being integrated across various platforms in the back end, and they're contemplating the usage. They're contemplating the impact of misinformation via AI, and they're contemplating, you know, policy reforms, and what it is that they, from a departmental perspective, had to contemplate on from a legal perspective, from a regulatory perspective. And Dina, I suppose it brings it to you to ask the question, you know, what do you see as that sort of interplay between AI and the law from a practical perspective, you know, from an IP law perspective? How's that sort of coming to fruition in terms of how you see it play out in practice from a contractual perspective, or a tort or delict perspective? And how's that also playing out in terms of liability? Because I think for a lot of our clients, for a lot of our, you know, colleagues, we need to almost revisit the way that we've been lawyering for the last couple of years, because it looks like, you know, based on what Herman was saying a little bit earlier, the world is changing. Surely we've got to start thinking about how we're going to be changing. Dina, I think you're on mute.
That's the cardinal sin. Apologies for that.
Always.
Thanks, Tayuba. I think you know, the biggest question at the moment is obviously from an IP perspective. You know, the IP world's kind of reeling at the moment because you know, we're in a situation where we just don't know who owns what rights, and you know, that question, or the answer to that question, I think will also start informing, you know, a lot of other legal questions. So, for example, you know, liability. You know, if you're going to be owning rights and you have rights to monetize, then, you know, with great power comes great responsibility. So, so at the moment, we you know, we are waiting sort of some kind of certainty on those outstanding questions. Now, I think, you know, firstly, I just want to point out that you know, in terms of IP law, it's not that, you know, our current law doesn't, you know, is not able to protect AI products and services. To a large extent, you know, it can. So, for example, when it comes to patenting, you know, inventive AI processes, excuse me, you know, our law does provide for that, provided you know, that it provides a technical solution to a technical problem. So, so for example, what we would consider is, okay, you know, does this invention have technical features? And if we consider only those technical features, you know, does the invention provide a non-obvious solution to a technical problem? And that might be something like, you know, it saves money, or it increases processing speed, or it increases the security of a system. These are all, you know, technical problems that could have solutions in AI. And those actually are patentable, even currently. What we don't have clarity on at the moment, and where we expect the law to evolve, is the issue of inventorship. So, you know, some of you may have heard recently, we had a patent application filed at the South African Patent Office for a food container that's based on fractal geometry. And the inventor is cited as DARBUS, which is an acronym, a device for the autonomous bootstrapping of unified sentience. And the application actually notes that the invention was autonomously generated by artificial intelligence. And of course, the poor registrar at the patent office didn't quite know what to do with this, because, you know, generally speaking, you know, the legislation provides that an applicant for a patent must have acquired the right from the inventor. And how do you acquire that right when you have a machine inventor, you know, the inanimate object that now, you know, theoretically owns some rights? And this patent or this applications for this invention were filed all over the world. And of course, the patent offices of these countries were sort of, all facing the same problem. Is it possible to cite a machine inventor? As it happened in South Africa, the patent was actually granted, but I think, in most of the other countries of the world, the decision was taken that at the moment we cannot actually have machine inventors. So that sort of thing, we're still grappling with. I mean, incidentally, the applicant, Stephen Taylor, he actually, if he'd cited himself as an inventor, probably, everything would have been fine and patents would have been granted. He was really trying to make the point that, he is not actually the inventor. It is invented by AI. So that's certainly sort of sparked a thinking on, well, the law has to evolve. On the copyright side, we have similar issues because, AI goes to the very heart of copyright law because, only an original work qualifies for copyright protection, and an original work is, it's obviously, the lowest bar is, it may not have been copied from somewhere else. Okay, fair enough. But the work must also have resulted from a substantial degree of skill or judgment or labor of the author. So here's where we get into a little bit of a sort of tricky ground because, well, okay, who is the author that is expending this skill or is using their judgment, skill, and labor? And we also have case law to suggest that originality, an original work must not have or resulted from an activity that is so trivial that it's just a purely mechanical exercise. And there again in AI, it's interesting because, this is a machine that is performing this function. So of course, it goes really right to the heart of originality. And beyond originality, of course, authorship is an issue because, if you overcome the originality requirement, then we're saying, okay, well, who is the author? So our Copyright Act is actually a 1998 act, and it's one of our only pieces of IP legislation that actually envisages that an author need not be a human being. So, for example, we've had case law that says the author of a computer program, which is the person who exercises control over the making of that computer program, could be a company, a juristic entity. So we have that, whereas conversely, for an inventor of a patentable invention, it must be a human being. And also in our Copyright Act expressly recognizes that a work could be computer generated, and that's where no human being can be directly, or the work can't be directly attributed to the effort of a human being. So the Act is actually quite progressive in that way. But of course, when it comes to generative AI, it's just not equipped to deal with this. And so currently there's really 4 schools of thinking at the moment as to, who's going to be the owner of the copyright. The first is there isn't any copyright because it doesn't meet originality. You don't have the skill of a human author being applied. The second sort of school of thought would be, well, it's the AI provided. They are the ones that have really trained the machine, to enable it to produce this work. So it's their efforts that are directly attributable, or that are, the work is attributable to their effort. And then, of course, there's the prompter. Does the prompter, if you put in a different prompt to an AI model, you're going to get a different answer. So is it not then, the author should be the prompter? And then I think the last school of thought is really talking about derivatives of the training material. Are you not using the training material to produce an output, and is it not therefore derivative work? that. So that's sort of where we are at the moment. And once we have some certainty on this, I think it's going to inform, some of the other laws around this. For example, I mentioned earlier, liability. And of course, we've got lots of other legislation that's already relevant. We've got POPI, as Sahiba, you're more better qualified than I to talk about that. Possibly ECTA might be involved. We've of course got contract law. You're using training material that you need to be authorized to use potentially. So there are all these things, but from an IP law from the perspective of an IP attorney, we're of course just waiting for some directives on these key issues.
Yeah, it's a complex sort of legal framework, and it often brings to mind that the story about the photographer who left his
Yes.
phone in the tree and let the monkeys
selfie.
take selfies, but then didn't actually earn the copyright in those photographs because he didn't actually take them.
Yes, so actually we've been grappling with this for some years already, since the monkey selfie.
Since the monkey selfies, and the complexity, in terms of, from going from the token, and certainly from a generative AI perspective, is you start at that tokenization, and there's an embedding, there's a coding and a decoding, and what happens somewhere in the middle there, we don't necessarily know in terms of the that we don't know in terms of the proprietary algorithm, in terms of how the source data is actually being adapted and utilized, and ultimately delivering on an answer that you're perhaps popping into ChatGPT. And that introduces, I think, the ethical quandary linked to some of the legal challenges that we're facing, back into, well, what are the ethical frameworks, and it has huge implications to my mind in terms of labor law, how we deal with employees by virtue of it. And then you can sort of envisage how it's going to start to impact. A couple of years ago, people were saying that the AI was doing radiology reporting, far advanced radiology reporting than the radiologists, and that dependency that we then suddenly have on the AI to provide medical advice, to provide legal advice, and certainly from a medical perspective, as a vocation, we have trusted healthcare professionals. There's a change in terms of how we will utilize this, and what ethics and ethical legal frameworks we're going to have to manage. Vanessa, perhaps you've got some thoughts on that.
Sure, Tahiba. Thanks for the introduction. Yeah, so if we go back to 2019, the OECD adopted AI principles, and just in a nutshell, they say that AI needs to promote innovation. It must be transparent, trustworthy, robust in the sense of security. It has to also respect human rights and democratic values. When it comes to the human rights question, that is about, we see protection of people's right to have opportunity when it comes to decision making, and obviously people's right to not be harmed when it comes to implementing AI. So if you look at, you've referenced two professions, our legal profession and the healthcare profession. And in both of those professions, you're relying on trusted experts. And we know that what lawyers sell are professional judgment, skill, and expertise. And we also know that we've got confidentiality and obligations. There's attorney-client privilege. And so with that, when it comes to using AI in our profession, you need to do it in a way where you're definitely not going to disclose any confidential information of clients. That's huge. And I think with these models like ChatGPT, you know, you can't just go and input a whole lot of confidential information in as a prompt. So, you know, that sounds pretty obvious, but you know, from the inquiries and the requests that we've had at Spoor to prepare AI usage policies, they've been kind of why they came up was where they've been quite senior employees inputting highly sensitive and confidential information that's proprietary to the company into prompts. And if you look at the terms and conditions of these, you know, ChatGPT, there's no obligation to keep anything confidential on the side of the provider of the AI. It's very vague, and so, you know, care certainly has to be taken from that point of view. And then also, we've got professional integrity, and you can't just, you know, rely on AI to do your job. And that's also definitely, in the healthcare sector, this is where decision making and human rights comes in, because when it comes to decisions around treatment protocols, obviously these are very careful decisions. I mean, I even personally, from situations I've been in medically, everyone knows my IVF journey of 17 IVF. Sorry if it's TMI, but I do know at the time the doctors would actually, there would be several doctors meeting about our case and applying their minds, and then, you know, I would consult with the doctor, and he would say, listen, we've discussed your case, we've met, you know, I've met with this expert, that expert, and this is what we think. And I mean, I was highly privileged to have access to that kind of medical support. But where you have these centralized databases of patient information there, and you then have these kind of rote AI decision making, you can see how people's access to skilled medical care can be compromised. So, and also obviously, and you can chat about this, Tabia, because this is in your area, but from a privacy point of view, there are these vast amounts of centralized patient data, which has to be protected. When we talk about, you know, what principles should apply to protect these issues, like fair decision making, and that doesn't compromise human rights, and that's also very interesting in the recruitment and academic space, where people's potential opportunities for their careers and academic opportunities are being considered and decided on. So, you know, that's where the human rights issue also comes in. So the front runner of regulation around this is, of course, the EU's AI Act. And what essentially the framework there is, they've categorized AI systems into like the good, actually the bad and ugly that are banned, to the dangerous ones like AI systems in aviation or motor vehicles, or, you know, medical devices, to AI that could potentially have a problem like your ChatGPTs, to a more friendly AI systems that deal with the narrow procedural tasks. Okay, so the really bad and ugly ones that use like subliminal methods, and I'm trying to find in my notes here some bad things. Subliminal or purposefully manipulative or deceptive techniques to materially distort behavior, exploiting vulnerabilities of a personal group due to specific characteristics, biometric identification and categorization of people, facial recognition databases based on untargeted scraping, inferring emotions. This is scary, this one. Inferring emotions in workplaces or educational institutions, except for medical or safety reasons. Real-time remote biometric identification systems in publicly accessible spaces for law enforcement purposes, except permissible purposes including the prevention of human trafficking, sexual exploitation and terrorist attacks, and social scoring systems leading to unjustified or disproportionate, contextually unrelated, detrimental or unfavorable treatment of natural persons or groups. So those are the really ugly AI. Sometimes it's allowed to prevent terrorist activity and trafficking, but those are banned. Then you have the dangerous ones that I've mentioned that are going to be used like in civil aviation. Like, I don't know about you, but I kind of don't want to get on a plane that's piloted by an AI system, although we already have like automatic pilot and cars and that kind of thing. And those AI systems in the EU are scrutinized. I mean, they can't go on the market unless there's been a whole story, okay? And then you have the potentially dangerous ones, where those are like your general purpose AI models, providers of GPAI systems like ChatGPT, and those ones you've got to maintain up-to-date technical documentation for the whole life cycle of the AI system. Policies have got to be put in place to show how you're respecting copyright and publishing. You've also got to publish detailed summaries of content. And it's interesting because the AI Act is very wide-reaching, and it extends to providers, which is broadly defined. And if you're a provider and you place the system on the AI market, or if your output is used, sorry, the EU market, or if the output is used in the EU, or you're an importer of an AI system, you're all caught in the net, and there's huge fines, which we'll talk about later. But, you know, it's similar to this, the GDPR with Poppy, where you see in agreements in South Africa and obligations to comply with the GDPR, and in a similar way, the EU AI Act has got far-reaching tentacles. So if you've got a, you know, so then you look to see if you've got a bad and ugly AI system, a potentially dangerous one, and so on.
Yeah, it's definitely a difficult thing to contemplate in terms of how you know, that AI Act is actually going to be enforced, and what the implications are for industry and what the implications are for innovation. Because certainly, you know, the more sort of regulatory burden you put on, say, the small, you know, technology innovator in his garage who's playing around with AI, the less likely that's going to make its way into the mainstream if it's over-regulated. And you know, the constructs around what our rights are, from a data protection perspective, so at the very heart of it, a constitutional perspective, is that we have a right to privacy as individuals. You know, we have a right to have a say in terms of what's going to be done with our information, how it's going to be utilized, and how it's potentially going to be monetized, how it's going to be rearranged and potentially reformulated. Certainly, you know, all of those things have implications from a legal perspective as well, because POPIA and GDPR contemplate that you would need to have the consent of a data subject. But for businesses, it also presents a slightly difficult thing. And I think Simone Zanetti might have asked the question around confidentiality. So confidentiality is, you know, it's a common law construct. It's been well sort of versed in terms of our jurisprudence. But attorney-client privilege is a higher level of confidentiality that we owe to our clients, and it is by virtue of the statutory role that we as attorneys hold, and our ability to actually hold, our ability to apply. So of course, if you as my client come to me and you say something to me in confidence, I'm not obliged to tell anybody by virtue of any law. I cannot be compelled to break your confidence. And that's an area of the law that's also been explored by the courts. But if AI generated the advice and I just handed, as your attorney, that advice to you, there's a question in terms of whether there was that construct of privilege and the confidentiality associated with that, which is critical. The second thing that's really important to bear in mind in terms of both the construct of confidentiality and the construct of privacy is that it is consent-based, and the advocacy for that is it needs to be informed consent. If you're taking someone's confidential information, and albeit that it is being maintained within the construct of a license that is confidential, what's more important is whether somebody has actually given you the authority to use and or misuse that particular data. And that's perhaps some of the legal challenges that come with AI. And it brings us to the construct of transparency, which is, I think, what we are actually having to grapple with. And you could see even in the hearings last week with the government that they are struggling to understand, what is the level of transparency that they can insist upon in terms of how AI tools, AI solutions are used, and what they can be used for or misused for. And you would have seen Scarlett Johansson take a court case where she's basically protesting the utilization of her voice. And so that transparency is really important. And Herman, perhaps I can come to you to ask the question in terms of, where does that accountability sit in terms of the transparency, and what are the implications in terms of how AI can be used and or misused in terms of that transparency and accountability?
Yeah, thank you, Tiba. I think firstly, it's important that we consider legal risk and also reputational risk. So a lot of times people consider legal risk, but there's, like we've seen, there's huge amounts of reputational risk by the misuse of AI. Now, my advice would be for leadership of any organization to commit at the outset to the ethical, moral, and legal use of AI. It's got to be responsible use of AI. And if you just look at things like you've and Vanessa discussed now, automated decision making, it's important that these algorithms and processes are documented. For example, they've got to be able to produce explainable, transparent results. And we understand why you want to move to automated decision making in order to get the benefits of the improved efficiency and turnaround times and overall customer experience. But at the same time, there's risk in terms of bias and unfair discrimination, like Vanessa has alluded to. So, organizations have to consider that, and they've got to consider, especially in industries like the legal profession, where again that human-machine collaboration takes place, and what they're comfortable in outsourcing to machine, automated decision making, and what type of decisions they would like to retain for professional oversight. And I think in terms of the legal profession, AI is, at least still at this stage, very much a tool that's used in the rendering of legal advice and services. So my advice would be, to think carefully about that collaboration and ensure that you've got professional oversight, at least on those critical decisions. I would certainly recommend that the professional, there's some sort of, application of the mind in rendering that advice, even though you'd like to use the AI in getting to the answer. So that's just some comments. I think Vanessa
Yeah.
covered more the legal aspect of it. So I'm trying to summarize more from a practical point of view, because we don't have an AI Act yet. I mean, we should be careful not to, think that the EU AI Act doesn't apply, especially given, the global reach of processes and businesses and where information is stored and accessed. You could very well, find yourself in a position where the EU Act does apply. But currently, I mean, we don't have a local AI Act. So I think it's imperative that business leadership take cognizance of these issues and commit to the responsible use of AI.
Yeah, and I mean that transparency in terms of the automated decision making. I was at a presentation yesterday, and in terms of the transparency, they were utilizing AI to kind of create profiles for women in tech and tech lawyers and the like. And they didn't necessarily have a profile that came out from AI for Black and brown women. And that was in of itself interesting, because that means that the source of the data is inherently sort of almost perpetuating some of the discrimination and the bias that we encounter in society. And you would have seen that a couple of years ago. I think it was IBM. I was always a little bit upset about it because they called the bot Tay, and Tay is my nickname. But it, within a matter of days, it was racist and vile. And so that becomes hugely problematic in terms of whether the source of information is in fact going to, by virtue of automated decision making, perpetuate biases and discrimination. Perhaps Dina, to come back to you, that bias, how are we mitigating? How do we envisage that needs to be mitigated in terms of the discrimination?
Yeah, Tay, that's a great question. The bottom line is, as Herman was saying, if you are providing, well, Vanessa as well, if you are providing an AI model, you have an obligation. You have certain obligations, and one of the key ones is of course how you are training that model. So, training an AI model is a lot like, I suppose, it's a lot like a child learning. If your child has only ever seen Yorkshire Terriers and associates dogs with Yorkshire Terriers, when they see a bull terrier, they're going to think it's a monster. They're not going to think it's a dog. So the bottom line is, you have to provide a very large data set. You have to provide a very varied data set. And in fact, the EU regulations, they talk about the statistical properties of your training material must be met at the level of individual data sets or a combination thereof. So if your training data set is too small, if it contains a large amount of irrelevant information, so there's noise, or if you train your model too long on a particular data set, you are, or a particular sample, you're going to get a bias. And this is, incidentally, it's also linked to infringement, which we'll get to in a second. But basically, if your model is too closely trained, it results in what they call overfitting, and overfitting results in bias and copyright infringement of the training material. So, we've seen lots of examples of that. Vanessa can probably comment on the issue of I think it was an Asian model whose body was used by an AI model, but her face was replaced with a Caucasian face. So probably your AI model has learned on a set of data in which models, supermodels, are tall Caucasian women with a particular, BMI, and it therefore, when it's generating a picture like that, it of course, will replace the face with a Caucasian face. So, this overfitting is, it's a massive issue, and I think so. When you are providing an AI model, you have a responsibility to train that model properly. So I mean, the same thing kind of occurs with copyright infringement. If we look at what constitutes copyright infringement, just generally, there needs to be an objective similarity between the original work, and the allegedly copied work. So copyright obviously prevents copying. It prevents making an adaptation of an original work. And if you own the copyright in the training material and you see an AI model that's creating an output, well, I use the term creating broadly, but creating an output that is objectively similar to your original work, that is training material, you can say, whoa, hold on a second. And of course, we had the case, with the New York Times, where ChatGPT, I think it is, or Microsoft's AI model, is basically reproducing large tracts of literary, literary works. And it's, incidentally, copyright infringement, it's not always about how much you copy. It's sometimes about, which part are you copying? Are you copying, the most important part because you couldn't find anything else on this particular topic, of the training material? Or are you, to what extent is there a sort of diminishment of the original work that really that results in the owner of the copyright in the original work not being able to monetize it anymore? And that's exactly what's happened, in the New York Times case. Because they're saying, well, hold on a second, all our users, are subscribers. They are, they're subscribed to get their hands on this, on these articles, and you are now reproducing these articles, for anybody. So that's kind of how the infringement happens. You are training it on too little information, too little relevant information, and you essentially get you get a situation of infringement of the training material, or the bias creeps in. Incidentally, if you're not actually, you might also have heard of sort of hallucinations by AI models. So that's where, they look at a set of training data, and they find a pattern, but the pattern is kind of more coincidental, or it's not based on, an actual, they come to a conclusion that's not based on the actual facts. So you also get, you might get a hallucination if your training material is too full of noise, or if there's not enough training material. So these are all things that, an AI provider has to, has to be wary of, because, well, hopefully we'll get clarity on this, but there is going to be a liability aspect.
I'm mindful of time and questions and the like, and Vanessa, perhaps just very briefly in terms of, what we can expect from the AI Act in terms of penalties, and perhaps you can loop into that, what are we advocating for in terms of best practice? I want to sort of hopefully get to questions in the next 2 or 3 minutes. So no pressure. You're on mute.
Sorry, that had to happen at least once. Yeah, under the AI Act, there's 2 things. There's really a monitoring system, because each member state has to establish or designate one market surveillance authority and one notifying authority to ensure that the AI Act is implemented. And then, as I've said, the AI Act is very broad, and the fines for non-compliance are steep, up to 35 million euro, or 7% of the offender's total worldwide annual turnover from the preceding financial year. So that's pretty massive. best practice, I would definitely advocate AI usage policy within organizations. We've already done some of these for clients. I would definitely, there should also be policies around data protection, data security, and also, yeah, I think directors have fiduciary duties of care and skill. They, the King Code also has, there are various committees under the King Code that deal with IT technology, risk, ethics. All those committees need to get up to speed on AI, and directors need to be aware of their fiduciary duties and duties of care and skill in relation to these new developments.
Okay, cool. Thanks very much for that, Vanessa. And in terms of going forward on AI best practices and how you manage that across your organization, obviously what we would advocate from a CDH on the primarily tech side of things is to make sure that you've implemented policies and guidelines in terms of how it's utilized within your business, with a view to protecting privacy, with a view to protecting IP, with a view to sort of addressing the constructs of how it can be utilized within a function, how it can potentially be abused within a function. Certainly we have to do that for our young lawyers and older lawyers as well, across our firms. Yeah.
And I think I'd also just be very mindful of the service provider terms and conditions. As I see in the chat, the question came up about, well, the service providers, the terms, they say they're going to be confidential. Also, if you look at they're going to protect your confidentiality, or if you look at the terms of use, they are like permitted, where the service provider says, oh, we'll only use it for these permitted categories. But you need to be very careful about those terms and conditions, because number one, they're very broadly defined to capture the service provider and every affiliate to the nth degree in his dog. And they also, they might have terms and conditions that sound pretty reassuring, but when you look at the detail, they're actually not. Like the permitted, when they say, oh, we'll only use them for these permitted uses, but they're not talking about, they're not being clear about, this belongs to you, your inputs are yours, we're not gonna provide, they don't, sorry, I'm getting all tongue-tied, but basically the service provider doesn't provide any undertakings that outputs are free from infringements of IP and third-party rights. So look at the detail and don't be kind of too comforted by broad reassurances, because really the devil's in the detail with those terms and conditions. And yeah, so just take care when reading them. And
the funny thing is, we're the kind of people who write those terms and conditions.
I know, that's why I know.
And we write.
That's why we know exactly.
We write them, and I mean, to be fair, we write them because we understand that what is imperative for businesses at the moment is data monetization. And so it's very well thought through. But it is important to be mindful of what the implications, because you certainly wouldn't be putting terms and conditions down that wouldn't allow you to, strictly speaking, monetize and utilize the full breadth of data for your benefit as an organization.
Yeah, correct. And the user's getting an amazing tool. So there's a balance. You can't expect the world. But I mean, that New York Times case, that article is well worth a read, because that just shows precisely how, outputs are not necessary, that they're third-party rights in there. So, beware.
Yes, absolutely. I think Farah has asked a question, and I'll take it from a CDH perspective. So automated decision making, and what we're seeing by virtue of from a labor law perspective, is already sort of dealt with to a minimum degree within Hofmeyr, right? And so the information regulator has a high degree of interest in terms of how AI is potentially being utilized from an employment law perspective. So, when they're doing assessments, it's something that they specifically query and are specifically interested in. We have seen laws in the likes of Germany from a labor law perspective in terms of, how AI is potentially used, and whether obviously the AI Act now would prevent the utilization of it to the detriment of employees in a particular way where it would essentially embody biases. Have we got a legislation on the horizon? I'm not necessarily aware of any legislation, but we are as a country generally slow to legislate. And I think people are still grappling with what the implications will be. I don't believe that they're going to be, imminent laws, but I wouldn't be surprised that at some point we will probably regulate always from a labor law perspective. If we don't regulate from a labor law perspective, we will have case law eventually that will be guiding light, I think, in terms of how we apply some principles. So I think there will be some jurisprudential framework eventually. To just perhaps go down to another question. I don't know whether the team has seen the question from Lunga Mafana, and perhaps I don't know who's the best person for the question. It might be let's go with Herman. He's talking about the South Africa's recent introduction of a digital nomad visa, and whether there are any particular key legal and ethical considerations for AI, especially regarding the cross-border IP rights and the potential liabilities associated with remote AI development work within South Africa.
Well, if you don't mind, I think I'm going to pass to Dina. This is actually what she does at Spoor.
Okay.
Yeah. So
I was trying to be gender balanced.
Okay, so basically, in terms of IP rights generally, and I just have to preface this with a bit of a disclaimer. Intellectual property law is it's quite complicated, and so everything depends on what type of IP we're talking about, who will be the owner, etc., etc. But generally speaking, ownership stems from creatorship. So if you are the creator, you are then the owner of the rights that are associated with that IP. There's one big exception, and that is employment. So in South Africa, typically an employer will own IP that results from activities done in the course and scope of employment, as by an employee. So to answer Lunga's question, we don't see any problem with there being a sort of local creator of IP in South Africa. If they are employed, in other words, if they're employed by a foreign employer, and that salary is coming in every month in a foreign currency, our legislation provides that that foreign entity, the foreign employer, will own those IP rights. Like I said, there are exceptions, so this is really just a kind of a general indication. If they are contracting, so if it's not an employment relationship, then things start to get a little bit complicated, because we do have exchange control regulations. So it's very difficult to assign IP to a foreign assignee. Under even a contract of services, you need to get approval for that. So that's where things start to get a little bit tricky, where you need to, the moment you are assigning rights to a foreigner or waiving rights in favor of a foreigner, now exchange control issues, come into it. So by all means, we want to encourage development in the AI field by South Africans or people living in South Africa, resident in South Africa, but they do need to be mindful of exchange control regulations.
Okay, cool. I think I'll speed through the last question in terms of fiduciary duties. Obviously, I think that in terms of automated decision making, the accountability will fully lay with the director, whatever AI may have been utilized. And I think that would have been for any other application that a director might have relied upon in terms of their decision making. But Vanessa, I don't know if whether you want to perhaps
Yeah.
Vanessa's put in a
Yeah, that was a very short answer, but yeah, it's the same where we talked about healthcare professionals and legal professionals. You've got this, you being relied on for your professional or fiduciary judgment, you know. So while you can AI, it's safe when an AI tool is doing routine tasks, but you can never abrogate that decision making to a tool, because, and remember, the board of directors is the mind of the organization. It's the controlling mind. So it's the fiduciary duties and the duties of care and skill.
Great. I think we've run out of time. It was quite like I said, you know, we could probably go for another hour, and we perhaps didn't even get to all of the things we wanted to talk about. But from all of us here at CDH and Spoor Fisher, very grateful for everybody who attended, for the sort of vigorous discussion on the chat, and for allowing us some of your time to be able to present. We obviously welcome you to reach out to any of us in terms of any support that you may require in the future. I wish you all a lovely rest of your day.
Thanks to Eva.
Thanks very much to Eva, Dina, and
Thanks to
Hannah.
Eva.